Good evening, everyone. Here we are here again tonight. In the case of Karen Reed, in the Canton PD audit, we're talking about the preemptory challenges, cause challenges, and more. And then I'm going to end with a 5-minute opening statement. What I can tell you about this, let's get first to the Canton audit, the Canton PD audit. That showed that there was the investigation into it, and they found that the conspiracy did not exist. That's first and foremost. That was an independent audit. This was something that people have been saying, "Oh, wait for the audit. Oh, you're going to wait." Like the audit said exactly what people already knew. It was that there were mistakes in the investigation, but they didn't they didn't screw it up. They didn't plant evidence. 40 people didn't conspire to frame this woman. That's kind of what it said. How it might come out at trial, I definitely think that if the defense kind of tries to go there and been like, "Oh, did you know there was an audit?" I definitely think Hank Brennan is not going to allow them to just simply put it in the jurors' minds as, "Oh, they're being audited," or something like that. He's going to be like, "Yeah," and get into it, like during the rebuttal case, be like, "Yeah, they investigated. There were mistakes done. Nobody's disputing that, but there was no conspiracy. This was an independent audit that the town paid hundreds of, I think it was like $185,000 for, and they found no conspiracy." And it's the same thing when what happened last week, where Judge Canonian said that Colin Albert couldn't be used as a third party culprit. That Brian Higgins, Brian Albert were okay to go there, but it was the level of evidence they have against them is so low that they might need to rethink their strategy. So I definitely think that the Canton audit could play into the case, but I think that since it came down after the jury started like during the voir dire, it'd be kind of difficult. I don't really see an upside for the defense because it doesn't say what they want. It just, you kind of can throw it out there to make the jury think. I am talking a little bit softer than normal because I have a very commanding voice, but my daughter's on the other side of the wall and I'm trying to keep her asleep because I've been trying the last hour to get her down that she gets a good night's sleep. My wife is at a conference in Arizona. So since Saturday, it's been her and I. It's been great daddy daughter bonding time, like playing and everything. And it's just a great experience. She'll turn 13 months next Tuesday on tax day. So April 15th, she'll be 13 months. And it's also the 5-year anniversary of my Nana's death. So April 15th, and as well as being tax day. So it's kind of like I don't know, bittersweet day, as well as, I don't know, my dad's an accountant as well. So it's a big day for everyone. What I can tell you is this. Because I saw a lot of people talking about preemptory versus cause challenges, and people thinking, I think I saw reporters saying cause challenge, you don't need a reason. That's not entirely accurate. Even when you do a preemptory challenge, so I'll back it up a bit. A cause challenge is when you have unlimited cause challenges. If you don't feel like this person may be biased, have a preconceived notion of the case, you can bounce that person off the jury. You don't need, if the other side usually will agree, but if they're going to try to, you can build credibility with the other side if they're like, "Yeah, we agree, that's not a fair and impartial juror." I don't know, based on how this case is played out, that either side is going to go along with anything that the other side proposes. But at the same time, they make the objection, the judge decides. The judge could either overrule the cause challenge and keep that person in the juror pool and be like, "Yeah, I agree. They said so and so. They said they couldn't be fair and impartial," and that's the end of that. So you can do as many of those as you can. And that usually happens when somebody says, "Yeah, I saw about this case and I read up about it, and I think I've made a decision about evidence without actually seeing it." That's an automatic, you're gone. Because I think I saw today pretty much everyone had heard about the case, which was pretty difficult to. And I'd say half had already formed an opinion on the case. So it's getting more and more difficult for them to find people who haven't been involved. What's my background? For those who don't know, I am a former state attorney, so I did that for over 3 years. And I've been a criminal defense attorney since November 2021, so about 3.5 years. I've tried over 40 cases. I actually have an attempted murder case starting on 4/21, and then I have the NFL draft Thursday, Friday, Saturday of that week. So we might be doing like a draft special. I talk about experiences being an NFL agent and like talking with teams and everything that goes in to kind of give you a look behind the curtain. But if you're more true crime, you might want to skip that episode. But yeah, so I do criminal defense, personal injury, sports law, and entertainment law. So a lot of cool stuff. I've had interns, sports law interns. So we do a lot of, had cases against Major League Baseball. So a lot of cool stuff. My client, yes, both my clients have had interest from the New England Patriots. So I can just let you know, Florida, the state of Florida. But I'm originally from the Commonwealth of Massachusetts. I was born in Quincy, and no, I do not know Michael Morrissey. For the question, I think I've answered more than any other online. Besides, how do you have clients? I was like, well, I'm exceptionally good at what I do. And when I do an exceptionally good job for them, they tell their friends, and then I do a good job for them, and so forth. I've spent very little money on advertising. It's very just kind of homegrown, building my business that way. So back to cause challenge versus preemptories. Preemptories, you only have a set amount of those. You only have 16 in this case. I think we said today the defendant stated to press that they've used 10 out of 16. That's a little shocking because we could have another 4 days of this and you only got 6 more preemptories. Preemptories mean that you can challenge anybody off the panel. You don't need to give a reason. However, if it's an individual that other side feels like maybe it's race related, like say it's an African American, the other side can ask when they're using the preemptories, I need a race neutral reason. And that's the most common one. When I was still a state attorney, what I also found when I was doing research for what I heard is there was I think it was a Supreme Court case that mandated that gender neutral reasons are also required. So it's not just race neutral. You can also do a gender neutral. So I was doing a domestic violence case, and the defense was trying to bounce a female juror who I kind of figured would be more sympathetic in domestic violence cases where female jurors and there's a female victim, they tend to be more sympathetic and much more understanding. So I said, I'm going to need a gender neutral reason. And the PD's office, public defender's office, looked over like, what, a gender neutral? So the judge, this judge was she wasn't really experienced with criminal law. She was more like a judge magistrate. So, but she eventually she had been passed over so many times, but she was good because she did a lot of research. She pulls out this book about this high. If you can see my hands, that's how high the book was. And she plops it onto her table and flips to the section. And then she's like scanning and she's like, Mr. Tepanek is correct. Gender neutral is a reason for a preemptory challenge. So then the public defender's office looks over and they're like, and they couldn't come up with a reason. And that person stayed on the panel. The guy was later convicted of the crime for domestic violence. Yeah, the cop witnessed this victim get backhanded, or actually not backhanded, open hand. I'm not going to say what I actually said in court because what I called it, because it was a slang term and it got my point across, but the judge didn't really like it. But it didn't matter. He was convicted and sentenced to jail time. So when you have preemptory challenges, the process usually is you target specific individuals with your cause challenge that you don't want on your jury. You know, when you're reading off their bio and what they have and you're asking them questions, you're like, I don't want this person on the jury, or I want this person on the jury. If you don't, your first step is always to try to see if you can get the other side to agree to cause challenge. So you're asking them questions and you get them to say things which they can't really argue is not a basis for a cause challenge. Like say they've already had this biased, or they say things that you know that the court is not going to agree with. If you're really good, you find a way to get them to say something that the defense doesn't want, for a reason the defense wouldn't want them on their jury. So you gotta keep picking and finding that stuff, so that if they agree, that makes it easier. If both sides agree, the judge is like, yep, this person's off the panel. Or if it's a situation where kind of like an agreement. It's like we both don't want him on there. Let's save our preemptory challenge, and just simply cause challenge this person. So anyone who's usually a cause challenge, who the the defense and the judge doesn't agree should be a cause challenge, is usually going to be a preemptory challenge, because you've already made that determination that you don't want this person on the panel. They've said things that it's like, I don't think this person is going to be open minded, or if they do, I feel like they're going to be sympathetic to the other side. And you don't want that. You don't want somebody so blatantly in your face telling you. So, like, perfect example with the first trial, it was pretty clear to me with the how the rule, like how like the alleged um, jury vote came down on the manslaughter charge, that there were people on the jury who weren't going to be swayed no matter what. And the problem was is that the prosecutor, ADA Lally, didn't do the greatest job of water iron, because if he did, went a little deeper, he would have found that these individuals were like, we can't have these people on the jury. And the same goes for alternates, because at any time somebody might get sick, somebody might, excuse me, somebody might be in a position where they can't make it through the entire trial period. And that's something that's very important, is you got to think of people who are on the alter as alternate jurors as people who are eventually going to be on the panel for one reason or another. So they're almost just as important, because if people, like I said, one or two people have to drop out, those first two alternates are on there. And if they're not on your side, that's a real bad start. What I can tell you is this: they've used already 10 out of 16 preemptories. So they only got 6 left. I think there was like a net 0, like they gained one person, lost one person, or somebody dropped out or something. I couldn't actually see, but there was no change in today. So for the next like 4 days, they only have 6 preemptory challenges. So they're going to try to cause challenge like crazy, because they're going to be like, all right, this person's already anti-free Karen Reed and all this other people. That's always what the defense is going to argue. Excuse me. They're always going to argue. It's like, oh, we can't allow this person. They've already made up on their minds. But the prosecution's also going to do it. So it's kind of like a back and forth play, in and out of like, okay, yeah, this person would be great on the jury. It's like, well, that's your opinion. They've said this, this, this. I have real doubts that this person can be fair and impartial. So I think I saw the state has used 11. So they're kind of along the same lines. Um, and remember, so if the defense is using it, they probably think that that person is part of law enforcement. That person is impartial to drunk driving. That individual probably is somebody who is going to be sympathetic to the Commonwealth, as opposed to the defense. This person is the victim of a crime. I'm sorry, has been charged with a crime. They'll say that, oh, yeah, law enforcement screwed me, but I definitely think I could still be fair and impartial. The answer is absolutely not. I've said this before in a previous stream. Somebody ever says to you, I can be fair and impartial, when they very clearly are giving you any indication that they can't be, get them off your panel and make sure you have them. And because you also got to know that every single person that every single person you talk to, you need to be sure that they aren't some kind of sleeper juror, because it does happen. It isn't. It is kind of like, I don't know if Runaway Jury. It's a good movie, by the way. Um, you have a situation where people are like have agendas. They want to be on a jury. Special ADA Brennan has been around for many years. Alan Jackson's been around for many years. They're knowing when people are trying too hard to get on a panel. Somebody's trying too hard, you have to look at them with real skepticism, because nobody really wants to be in a jury. I've had 6 hands. So I've done 42, 43 trials, and I've had maybe 6 hands go up when people have said they wanted to be on the jury. 5 of which I've impaneled them. 1 of which her hand shot up so fast I had to inquire, and she was like a legal aid person. Her brother had been convicted of an offense, and it's like this, that, and the other thing. And I was like, yeah, I love your passion. I love that you want to be on a jury, but a jury is not a place to be an activist. It's not. It's for people who want to come in with an open mind about the facts and the evidence. That's the only way the system works. People come in, both sides, prosecution and defense, and they're of the opinion that it's like, okay, yeah, this person's guilty, blah, blah, blah. Can we just get to deliberation? That's not the system. It's not going to work in this case if it needs to work for everybody or it works for nobody. It's that simple. And that's why it's I think Judge Canonian has been allowing a lot of things into evidence that she was like, all right, this is a potential appellate issue. This is a potential, all right, with the whole like when they misrepresented the ARCA witnesses as independent. The judge scolded them they still may get sanctioned at the end, but she didn't want to create an appellate issue, as we saw. Like the defendant filed a writ of certiorari, so the district court said no way, but you can appeal it just because you match the scintilla of evidence to do that. Then the appellate court was like, still no, and the Supreme Court, I say it's highly unlikely that they're going to intervene. Remember, a writ of certiorari requires 4 jurors so that to hear a case. So 4 of the justices need to agree that, okay, there's an issue and we want to resolve it. The reason it's a rule of 4, so even in the situations where the minority gets to have an opinion instead of 5, because if it needed to be 5, the minority would never be able to have a case heard. That's why it's always the rule of 4 for writ of certiorari. I don't really see it going anywhere. I don't think they're going to grant some kind of stay on the case. It's just kind of like a last ditch effort to try to keep. It's like, hey, and it's kind of like something. One of the observations I've made is the defense looks a lot less confident this time. I remember the first time they were coming in and they're like, "We got this in the bag." And you watch we'll talk about in a second, the Body in the Snow documentary. It was pretty clear that they thought they were going to win that case. They think they had given everything. They showed enough reasonable doubt. But the problem is that um, it's the tail light. That and the I hit him, I hit him, I hit him. It's just 2 things that you can't unhear. All these people all these people are lying, and then with the piece of the tail light on the clothing, the DNA, the hair. So if you one of the biggest question is all right, was the hair, John O'Keefe's hair had to be on the car. Did it get there because uh it was planted? Probably. All right, then you have to believe the conspiracy. But the first jury didn't believe the conspiracy. That means the more rational opinion is that the car struck him and a piece of his hair is on there and it froze. And that's why it was on this. Like, oh, how would it ever stay there? I'm like, it was in the middle of the blizzard. Are you not from the Commonwealth? Do you know how cold that is and how easy that would be to freeze there? So I've heard so many ridiculous things online throughout this whole case. So it's definitely just kind of like, all right, we're going to use common sense, be reasonable, and talk about facts and evidence. We're not going to talk about, it's like, oh, what about this person, or post a bunch of ridiculous pleadings. That's like, oh, this proves this. Like, that proves nothing. And it's just a lot easier to not even engage with some of those people because you're not going to convince them of anything. And you're just like, I got other things to do with my life. Like, seriously. So when it brings me to the documentary, I think it was well done. I think I've said before, I definitely think that it was done as hey, look at the dream team. Look at how we just crushed the state, the defeated the Commonwealth. And it's like building up to that. And one of the things I did see, I don't really know if David Yannetti is fully on board with the conspiracy. When you talk to him, because I remember he's been on the case since day one. And he said this was a tragic accident. And it wasn't until I want to say April 2023 when bloggers started to talk about how this conspiracy came to light and everything like that. I definitely I do remember the defendant saying, it's like, oh yeah, it's like we're all in on the same joke. Yeah, okay, you could say that. That's interesting. But one of the things Hank Brennan might actually zero in on is when the defendant is arrested for the second time, and she is saying that it's like, oh well, I'm going to be on Channel 4 News. I got to have better shoes on. I was like, it's like, I don't know if this is what you wanted to do. It's like, I understand your opinion, but it's like, this is not really the most important thing. Talking about your news and how you're gonna appear camera worthy. You're being arrested for second degree murder. I don't know if that's the best thing. And Um, her statements, everything that she said is going to come in. Anything she said on there, it can be admitted as evidence because it's admissions. And the using the actual words to be like, it's like, this is my testimony. I'm like, oh my God, please. That's just bad. That was like really like you couldn't have picked worse words if you tried in that case to be able to be like, yeah, it's like, do you really think that it's like, did none of your attorneys tell you this could all come in as evidence? If you said only like a few answers to a few questions that have already been answered that are innocuous, never, but it just, I don't know. It did more harm than good. I definitely think that if she got paid, it was definitely a monetary thing and to bring more attention to the case. Um, because yeah, I think something like I think there was like $5 million that they paid for the first case, something around there. Um, would you advise your client it's smarter to not do multiple interviews and hush up? Very simply put, if a police are speaking to you, the answer is I have nothing further and I want to talk to my lawyer. It's just that simple. You don't speak to police. You just don't. Do you know why? Because if you confess, they're not going to be like, well, thanks for being honest. We're going to let you go. No, you just made the case that much easier for them. So you ever get arrested or they're asking you questions, the answer is very simple. I don't want to speak. I want my lawyer. That ends all conversation. All you have to say is lawyer, attorney, or anything of that sort. You don't even say I want an attorney. You just need to say attorney or lawyer. Or if Spanish speaking, abogado. And they'll have somebody in the police who speaks Spanish be like, he's saying this. Um, for an experienced attorney, I'm surprised AJ didn't have more client control over her. I think he's just given up, truthfully. I think that she's turned this into a one-woman show, and nobody was going to prevent her from doing that, which I can't. I didn't see the upside in that case. I'm doing that documentary. A part of me literally thinks they're going to beat it. So this is her way of basically boasting about it and just like, hey, by the time you guys watch this, I'll already be acquitted and they can never charge me. So that's the only thing that makes sense to me deep down. Because otherwise, it's just like you're gonna watch yourself on TV. You're gonna watch yourself on a television screen in trial without even taking the stand. Um, so so I didn't think the documentary overall was that great for her. I think they did a good job showing both sides of it. But in the end, it definitely was just um, this is a marketing 101. Look at how great my team is. Because if we don't get paid again on the second case, we got the publicity associated. That's from the defense perspective. But I think their best opportunity to win the case and to get a straight not guilty was in the first case, first trial. I just I don't know, especially if if vehicle data is more broken out. I just don't know if she beats it. I really just don't know if she beats it. Um, but we'll see. Like I said, you keep an open mind. You have to hear all of the evidence before making a determination. It's just knowing what it is and seeing um, just seeing the difference in night and day. It's like especially ADA Lally did a commendable job, but unfortunately, special ADA Brennan is just on a different level of trial attorney. Um, it's it's like the JV versus the varsity team. That's kind of what it is, and that's what this case demanded. For the longest time, I couldn't figure out why a plea deal was never considered, and people like, oh, she didn't do it. It's like, well, um, if you're a great trial attorney, even the best ones know that it's like know the weaknesses in their case and know like weighing the risk and reward. And it wasn't until the documentary that I actually saw it. The defendant was like, even if I go to prison 10, 20 years, that's the rest of my uh, life that I'm going to be useful. And I was like, oh, that's what this is about. It's like, if you even take a 10-year and you're out for 5, it's like, that's it for you. And also the ride ends because the phone's going to stop ringing from every news outlet and blogger and this, that, and the other thing, because it's like, this whole conspiracy was a lie. Her pleading guilty, even if she's convicted, they can still say she's a wrongfully innocent person. The real killers are out there. That's kind of what I figured was going on. So, for an opening statement, what I would do is this. It would start with I hit him, I hit like I hit him, I hit him, I hit him. Like that's kind of where it is. That kind of is where it begins. What you don't want to do is you don't want to go Lori Vallow and say the evidence will show. That's the worst thing you can say. The more times you say that, you're just saying you've never tried a case. That's why Lori Vallow, I'm not going to get into that case too much because she's already had all of her attention given, and the things that she's done are just unforgivable, and she's not even worth the breath that I would use talking about her. But an individual who represents themselves has a fool for a client. That's Abraham Lincoln. So Lori Vallow representing herself, though her opening wasn't terrible, it's still really, really dumb. No matter how smart you think you are, never represent yourself. So I hit him, I hit him, I hit him. That's kind of where my opening begins. So it's like, all right, she's already admitted to it. Because what I said in the last stream is you need the jury after your opening thinking, what are we doing here? This should have been a plea. The defense will go on and we'll do that on Thursday. We'll do that opening. And then it's talk about, all right, then you go with the car. The piece of the taillight were found at 34 Fairview. Pieces of the taillight were found on the defendant's clothing. On the defendant's vehicle. The victim's DNA was found on the car. The victim's hair was found on the car. And regardless of what you hear, there was no conspiracy. So you're going to get out there immediately and talk about it, because if you don't bring it up, the defense will. And then everything you kind of said during your opening, they're going to be like, are they telling us everything? So you need to be able to both. This is kind of an interesting case. They're going to have to prove a direct evidence case in a circumstantial manner, which means is they're going to have to eliminate each and every person who could have done this, and then leave. And conclusion is there's only one person who did commit this crime. So kind of unusual. Usually you either prove the direct evidence or in a circumstantial manner. But with this conspiracy and everything and people buying into that and the intrigue, that's how you're going to probably have to prove it. Additionally, you're going to keep hammering the vehicle data. In the first trial, it was not explained that well. Like backing up 26.4 miles an hour, something like that. The person testifying did an okay job, but it was uncomfortable, and it was just like they don't really can talk about it. They don't really are explaining it, and the jury's like, so without it, it's like, I don't know how you get to murder. I think Special ADA Brennan is going to be able to get into that further. Can you tell us a little about Brennan style versus Jackson? Okay. So Special ADA Brennan comes from federal court, where it's far less theatrical and flashy. Special ADA Brennan doesn't get flustered. He just tells it like it is and just reads it. And there are going to be objections and stuff like that. And they're going to, the defense might object during the opening if they're doing well to just kind of throw them off their game. So when I was still a state attorney, there was assistant state attorney, who admitted in one of our Friday meetings that if she thought a defense attorney was doing good during cross or opening, she would cough and fake being sick, fake the issue to kind of break their momentum. She admitted to that. That I hate. I was not a fan of that prosecutor. I'm not going to say their name, but that's not how the system is supposed to. You're not supposed to do underhanded stuff like that, and you're definitely not supposed to admit it to 40 other prosecutors. So he's not going to get flustered. It's just going to be, here's the facts and the evidence. I'm going to tell you a story. And it's like their relationship was on the rocks. The defendant and the victim were fighting all the time. And the victim had stated, I think our relationship had run its course. And you're going to hear from the niece and nephew of the victim who overheard this very thing, that their relationship was not good. It wasn't healthy. And definitely talk about how it's kind of like we all heard the voicemails. It's like, John, I fucking hate you, and this, that, and the other. It's like, I'm here with your kids. And it's like, was she there with you? No. And people have made excuse for that. It's like, oh well, you know how women are. Sometimes they lie about it. It's like people are gonna be like, this is a real weird time to do that. And like they might give some deference, but it's just like the hearing is like, all right, this lady is drunk out of her mind. So this time around, I don't think the defense should try to argue that, oh, she wasn't drunk. It's like there was everybody in the courtroom, but the four of you thought that she wasn't drunk. It doesn't matter. Both sides, everybody, whoever thought whatever, was like, it was clear that's not where the case was. The case was, did she strike him or not? And you guys didn't spend enough time on that because you were too busy with the conspiracy that you couldn't prove. Um, so what else? Thoughts on Hank using consciousness of guilt and bringing Turtle Boy in? That's going to be probably something he's going to save for a long time because he was mentioned during voir dire. I think he's going to be called if they have these kind of messages and be called to authenticate it. If he takes the stand and he pleads the fifth, it's going to look horrific. It might actually look almost as bad as if he testified, Mr. Kearney testified against the defendant. It was then it's like who's has the conspiracy now? It's like I feel like the shoe's on the other foot, and then it's kind of completely dispatched. The evidence is against her. I'm certain, yeah. What does the Commonwealth need to do to get a conviction on second degree murder? So this is very important. You need to create, the defendant has to create a situation where there was a situation of serious bodily injury. It has to do that. That could lead to death. So they need to be able to show that she backed up at that speed, knowing that she could potentially hit him and that was foreseeable. It's kind of depraved heart murder. That's what it is in a second degree murder case. Uh, First degree murder is malice aforethought, premeditation. Second degree murder, you really don't need that much premeditation, more than like a mere moment. But second degree murder is usually depraved heart. So depraved indifference, you did something dangerous that you know could hurt somebody. And if somebody died, you're held responsible. So they need to get that accident reconstruction backing up and did it at a speed that in that snow, in that manner, a reasonable person wouldn't expect to be able to stop. That's how they get it. They don't prove that. I don't know if they're going to get second degree murder. And the fact that they haven't like dismissed that count makes me think that they can prove it this time around or explain it in a way that people would understand. Because otherwise, you take that away, then it's just like um, you have to prove a DUI manslaughter case, which I think they could pretty easily do if they have 12 jurors deliberating who came in fair and impartial. Are you familiar with the expert reconstruction that this Commonwealth is bringing in? I'm not really familiar with what they're doing, the accident reconstruction, but I definitely feel that if Special ADA Brennan has like enlisted this person, they're probably going to have a different take on it. And it's more that they've watched the trial, the first trial on how many times, and seeing it's like, what could we do better? What could this witness do better? Because this is, yeah, the entire world is watching. It used to be just Canton and the Commonwealth and people across the country. Now this is like a worldwide thing. I've had people reach out from Australia and be like, "What are your thoughts?" I'm like, "How do you guys know about this case?" And it's unbelievable. Um, yes, I heard in Massachusetts they don't plead the fifth in front of the stand. It's done in chambers. Yes, because there's an ethical obligation that if you know somebody's going to take the fifth, you can't put them on the stand. But you get to tell the jury that it's like this is what's going on. But that's usually, but if the defendant, but I have experienced cases in the Commonwealth when I was still a law clerk. Our client in a case took the stand, asked questions on cross during like a injunction hearing, and he's like, I invoke my Fifth Amendment rights. And that's kind of what happens. So it's sometimes, but they're going to bring him in there, and he's going to Mr. Kearney's make the decision whether to testify or take the take the fifth. And I think his attorney's recommendation is going to be the latter because it's like you're not doing any good. You testify unless you're given immunity. use and transactional immunity, meaning that anything you say cannot be used against you in any kind of proceeding. There's just no real upside, or you're getting some kind of plea deal. There's no real upside in testifying. Um, since Colin is out as a third party, will the state even call him or Allie McCabe? Um, it, it's an interesting question because you don't want to look like you're hiding from them. So if they don't testify, the jury might infer things they shouldn't. So it's kind of a toss up whether they should testify or not. They're not going to be able to argue them as third party culprit. But at the same time, if you don't call them, the jury might be thinking, why are you trying to hide them? And that's kind of the play. So you might want to just put them out there to show you're not really hiding anything, that they've been cleared, they're not being implicated, and they're just they're one of the people that says Officer O'Keefe never entered the residence, because that was a big piece of evidence and something that during opening statements is also going to be talked about by especially ADA Brennan. Is every single person in that house did not see Officer O'Keefe in it. So if all these people didn't see him, that means he never went inside the house. That's what a reasonable person would infer, that he did not enter the house. So if he never got inside the house, how is he beaten in the basement? He wasn't. So then it's like, okay, the snow plow theory, they're not going with that. So if he never enters the house, then and it's a situation, how is he killed? It was because the only facts, everything leads to one person. So that's kind of what the opening will be, is Special ADA Brennan is just going to keep laying out facts. And facts is like fact, fact, fact. I definitely think that he might want to get in front of the Michael Proctor stuff, so that when the defense takes their opening, that they don't look like, oh, you didn't tell us everything. You don't want to play the defense's game, but you also don't want to the jurors to be absolutely stunned when they hear that, because that's going to be a piece of evidence. It's going to be a bad day in court, like it was in the first trial. But if you minimize the damage, you might be able to minimize how much the jury cares and how much they're going to take it into account. Like inverted Sallyport videos. Yes, we've all heard all of the things, and it's just like, oh well, it's like, yeah, no nudes, and it's like going through and like making fun of the defendant's MS. All of that's going to come out and it's going to go to credibility, and you just need to get it out of the way. You need to discuss it, and you need to just end that, so that doesn't overtake the trial. So I definitely think, especially ADA Byrne is going to do something similar to what ADA Lally does. So, like I said, I hit him. The evidence from the taillight, the vehicle data, the drinking, the fact that every other person didn't see Officer O'Keefe inside the residence, and then, yeah, so that's kind of where it is. Um, why doesn't the defense shake it up and have Little do the opening and Jackson close? What could happen? I would, but I just review. The problem is that that's an interesting question, because Attorney Little is just not as dynamic as Alan Jackson is. That's the reality. And during opening, you want that jury's attention, so that they're taking notes. So like, it's not evidence what they're being presented, but it's a roadmap of where to follow. And I think I've said this before. It's very, very easy for a jury to tune out if they don't like what they're hearing and it's not engaging. And Attorney Little is just not as engaging as Alan Jackson is. I don't agree with how Alan Jackson kind of conducts and himself sometimes, or this conspiracy angle and just throwing anything against the wall. Doesn't matter. I get it, but I don't really agree with it. I don't think um, Attorney Little is going to be able to go toe to toe with Special ADA Brennan. I just don't. And the jury's just going to tune her out, and they're not going to be engaged. So I think it's going to be Alan Jackson opening. I think it's going to be him closing. Alacy possibly might open, but Alan Jackson is just way better than any of them. Do you think Karen Reed's attorneys are no longer being paid? It'd be really it'd be really bad business if their retainer agreement didn't say this covers this trial only. It doesn't cover a retrial. Or they're doing this entire second trial just for publicity, because it's really, we're talking $500,000, $1 million for each of them. And I don't know if you can get the publicity to generate that revenue, especially when you're running a business. Because when you're an attorney, this is all you're doing for 8 weeks. You're not bringing in new business. You're not doing anything but this case. So you need to be getting paid. So they might be taking a discount, but it'd be really tough for them not to get paid. So I definitely think yes, but she did say that the law clerk, she had like 9 of them, some from like Harvard, and they're like writing the motions. And it was pretty clear too, because when I was like Little or Yannetti or Jackson aren't writing these things, it might be an associate, but then we found out they're law clerks. So yeah, it was pretty clear. But so we'll see what's will happen tomorrow. I definitely think that the prosecution and the defense like has to be tactical with their preemptory challenges, because you don't want to be in a situation where you haven't fully impaneled the jury and you are out of preemptories. You do not want that, because one side could slip in a juror that they knew the other side would never allow on there if they don't have preemptories and they weren't cause challenges. So you want to use your last preemptory on the like right as you're about to impanel the jury. So I think that's all that we got for today. I will be back on Thursday night. Thank you very much.